lone lawyer.
Now we can go to work.
Yeah, I tell you, that WSJS orchestra is something else.
Well, they sit here all week waiting on this
I know.
30 minutes of fame. And
That's
so
right.
I hate to snub them when that happens. So let's. Bob's been hanging on for a couple of minutes. Let's talk to him. Bob, you're on WSJS. Good morning.
Good morning. My question is, I just found out I might have a daughter. She's 42 years old. Did lived in North Carolina, moved to Georgia, and she's made contact and didn't know I had a daughter, but we're doing a DAN test or DNA test at this time. What I'd like to know, she was adopted when she was a small child by another man in Georgia, and she lives in Georgia and she's married. What kind of recourse she has to come back to me? Is she entitled to a child's part of my estate or what?
Well, if she's been legally adopted, irrespective of whether you knew about it or didn't know about it, she's now legally the daughter of the other gentleman. The law does not require anyone to leave anything to their children. So if you don't have a will, of course, then you might get into a dicey issue about if somebody is proven to be your daughter. But at any rate, you can do your own will and provide who gets what, and the only one you really cannot disinherit is your spouse, unless you have a premarital agreement, spouse from whom you're not legally separated and still married. So you do not have to leave her anything. You would not have any legal obligation at this point that I'm aware of. But you sure should do your will in which you state. I think I would state in the will that I have a daughter, a biological daughter, and then provide otherwise that I'm leaving that child nothing for, oftentimes we'll say for reasons known to her, so nothing else said. But you do not have to, the only time you get into a child's portion is when you don't have a will. And then the law writes you a will, and the will that the law writes you divide your property among your spouse if one is living and you're not, and then your children. But I would say since the child's been adopted, that would be another strong impediment to her ability to claim anything in your estate. But you can do your will and take care of that.
Thank you, sir.
All right, good luck to you.
Thanks for calling, Bob. 777-1600, 777-1600. I knew a case about that one time where there was a friend of our family, and he and his wife, he was very elderly, and he had married this woman, and then they separated. She moved into one of his rent houses on a big farm, and they lived apart for years and years and years, but nothing legally was ever done. And when he passed away, she came back and rightfully did, because nothing had ever passed that said that she was not his wife.
Right, and that and she was able to establish a claim. That's right.
That's
so a lot of these things that you say, well, how can that be? Well, if you don't take charge by your own ability to define in documents, then as much as you can. So, and we see that lots of times too on change of beneficiary issues. After people are divorced, they don't go and get life insurance policy changed and things like that, and they just, for whatever reason, they don't go through and say, well, whose name, where is my former spouse's name on contracts with insurance companies and such, that you have to get cleaned up. If you don't, then some things that you wouldn't expect might happen.
Jerry, you're on WSJS with Mike Wells. Good morning.
Morning. Hi, Mike. How are you today?
Hey, how are you?
Thank you. Hey, I was just kind of interested in what is the difference between a judgment and a lien? Say like a mechanic's lien or something.
Right. Well, a mechanic's lien, and it's not just limited to mechanics who work on your car. That's a phrase of art that essentially says that the law provides that different people who come work on maybe on an item of personal property, like a vehicle, which would be one way, but where it's most often used is somebody comes out and works on your house. And I come out and work on your house, I do some roof work, and you don't pay me, then I can file a claim of lien that just says I'm in line on this title in terms of the chain of title, and then I have to file that within a certain number of days, normally 120 days from the date that I last worked on the property. But then I have to, within the next 60 days or so, as I recall, I have to file a lawsuit that says I worked on his roof and he owes me, and then I get a judgment that says that's right, you did, and you're owed X. Then when that happens, then I have a judgment, but the judgment jumps back to the time that when I filed that claim of lien. So in many ways they sort of work together, but you can, if you have a lien, if you don't get a judgment, the lien's going to expire or go away. So you really need to follow up with a lawsuit. That's what that means.
Okay. And normally when you follow up like that, it can be determined whether or not you get interest in things, correct?
Correct. And the law would provide, if you have a contract that provides a rate of interest, but then once you get a judgment, you get legal interest, which is 8% per year.
8% per year. And then the judgment is good for 10 years, and it can be renewed once, or?
It can be renewed once for another 10 years, correct.
Okay. Thank you so much.
All right, good luck to you.
Thanks for calling, Jerry. Let's take a break for an update from the WSJS News Center. We'll get to Sharon's question as soon as we get back, but right here is Smitty. 9:19, let's make it 9:20 on the Triad News Radio, AM 600, 1200 WSJS. Mike Wells is here answering your legal concerns at 777-1600, 777-1600. Sharon, thanks for holding. You're on WSJS with Mike Wells.
Well, good morning.
Good morning.
I have a question concerning my mother's will. She received an inheritance from her parents, and she has kept that money for my brother and for me, but she's put it in 2 CDs, and we are not listed as beneficiaries on that money. She's listed no one. She does have a spouse, my stepdad. My question is that she has designated that money to us in her will, but since she doesn't have a beneficiary on the 2 CDs, if she outlives my stepdad, if my stepdad outlives her, does it resort back to him as next of kin and he gets that money, or how does that work?
Does your mom have other assets, I presume, that could be what does the will provide about what your stepdad gets, or do you know?
She has left everything to him except for those
2 CDs. Right. Well, depending on how the will is written, if the will provides you get those CDs, or what would be the successor CDs, if you will, then those, even though they don't have beneficiaries designated on them, then that would sound as if they're going to go to you and your brother.
Okay.
Now, without seeing the will and knowing how they're designated and what happens between now and then, it's hard to say. But if she really wants to do that, she might want to think about listing you all. Does your mom still have her mind about her?
Yes, she does.
All right. She might want to list you all as beneficiaries, what's called payment on death. POD,
okay.
Payment on death, and she could list you and your brother, and then that would go to you all automatically. But you can provide that way, or you can have it go through the will, but you might want to put it on those documents, because that way it passes outside of probate and probate expenses.
Right, the payment.
Payment on death.
On death.
Yes, ma'am. Okay. Payment on death. The bank will know, or the institution will know what that means.
Mm-hmm. Okay.
Okay.
Well, thank you.
She can
thank
list JR and me too if
That's
she's
right.
looking
We'd be happy to take some of that. Sharon.
Yeah, we'll be glad to be her adopted children.
That's right.
Okay. Thank you so much.
Thanks for calling, Sharon.